GoatBoy the Beezo Clown.
This is your favorite auditor. Audit them. The channel that encourages you to audit them. This video is protected under the 1976 Fair Use Act, the Treaty of Peace and Friendship 1787, Title 18, 8 U.S.C. 1, 3, 2, 4, the Treaty of Madrid 1880, UCC 1-308, and Article 6 of the Constitution of the United States of America Corporation Company.
What in the do, Hickey?
Chille de Castro had his YouTube page disabled.
I lost my YouTube channel. How could I have lost my YouTube channel? All I did was to tell people to hit the like button. How will people know about the Mullen Commission? Everyone should know about the Mullen Commission. How will I be able to still sell my trifolds? The ones that have the charge, the held, and the fact? Essentially, they took away my ability to make money, particularly with my YouTube channel and my trifolds. We don't stop hitting the like button. We don't stop hitting the like button. We don't stop hitting the like button. Later, Gator.
Chille is very whiny today. He just lost his YouTube channel.
Well, he did this to himself. It was all his own doing. It wasn't just the trifolds that he was selling. He was a scammer and a grifter.
He did not have a real job that anyone knows of. How can a person expect to make a living selling trifolds of how not to react to a police stop?
Chille was always so confrontational. I'm glad you don't get involved with Chille's scams. I'm also glad that both of us have good paying jobs so that we don't have to be so dishonest like Chille.
Amigos USA. Amigos USA. It's disgusting to see two colonizers having a display of affection. Amigos USA. Amigos USA. If you continue any displays of affection, I will put a lien on you. Payable only in Moorish dolarium, backed by silver and gold, and not in corporational company Federal Reserve notes, as used in the United States of America Corporational Company. Amigos USA. Amigos USA.
GoatBoy the Beezo Clown.
I'm here in the Burnham, Illinois City Hall to make a FOIA request for the water atlas for the city of Burnham, regardless of form or characteristic. I'm here to conduct official business. I'm here to make sure that the City Hall of Burnham is conducting business in the public interest. I'm also making sure that all required information is being prominently displayed, especially the City Hall's block diagrams, which always must be prominently displayed. Otherwise, I will report the Burnham City Hall to the State Attorney General's office for being out of compliance.
Hello, how can I help you?
Good morning. With whom am I speaking with?
My name is Jessica.
Well, Jessica, I am here to make a FOIA request.
Are you filming in here? I am not okay with you filming in here.
I'm filming for the purpose of accountability and transparency. I'm making sure that the Burnham City Hall is working in the public interest and in complete FOIA compliance.
What did you need to file a FOIA request on?
I need to see the block diagram of the City Hall, and I need the water atlas for Burnham, Illinois.
Can't you make a request online?
Ma'am, the information I need is supposed to be already prominently displayed. And if it is not, I will have to put on my clipboard that you are not in compliance.
Compliant? With what?
Ma'am, the state of Illinois has statutes and ordinances which must be complied with. Ma'am. 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 Ma'am.
Maybe if you weren't so condescending, I would be more willing to help you.
You're not in FOIA compliance. Ma'am.
If you don't stop being a nuisance, I will have to call security down here. You don't want that, do you?
If you give me some FOIA request forms, I can put in my request.
Very well. If it will get you to stop harassing the staff. Here you go. It may take a week to have everything available.
All the information that I am requested needs to be already prominently displayed.
City Hall has other things to do. Have a nice day. GoatBoy put in his FOIA request forms and left the Burnham City Hall. He was not happy that the water atlas was not prominently displayed, so he had a mark on his clipboard that the Burnham City Hall was not in FOIA compliance, the block diagram was not prominently displayed, and was not working in the public interest.
It is unknown if the Burnham City Hall was actually reported to the Illinois State Attorney General's office. The Burnham City Hall is full of unspecified specifiers, bootlickers, and cessors. They won't take the time to print out hard copies of their water atlas, or even print out the block diagram of City Hall. Wait until the State Attorney General hears about this. Oh well. It's time for some Little Caesars pizza, and a few bottles of Corona.
GoatBoy the Beezo Clown.
My nationality is Mormish. Hey, Luna, do a super chat. Don't just talk about it. Do it. I need the money so that I can eat at Taco Bell. We're on the record for cases 24cc0104 and 24cc0109. Texas versus Antoine Davis-Bey. Mr. Bey, this is your motion to reconsider. I have reviewed your motion to reconsider. I have reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So Mr. Bey, you may proceed with any argument you'd like to make, okay? So this is a situation stemming from arrest from March 8, 2021, from a lawful arrest without a warrant. This is a situation between hypothetical suspicion versus a concrete crime, whereas in this situation, no concrete crime took place prior to the unlawful traffic stop, okay, the state has failed to even establish a probable cause for this arrest and search, and they had no justifiable basis as this to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law, for 1, the absence of a sworn affidavit of proper cause by arresting officer. A further arresting officer ran this arrest unlawfully, and the injured party or complaint with illegally recognized. Mr. Bey, my court reporter is having trouble understanding, and maybe slow down a bit on your speech. I want to make a note that the traffic stop and offensive possession of marijuana was dismissed in 2021, around the approximate time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an exhibit.
What in the doohickey?
Also, I wanted to point out the fact that this is a case of hypothetical suspicion versus a concrete crime, okay? The mere act of a traffic stop does not constitute proper cause for broader detention or search as recognized by Terry v. Ohio, okay? Hypothetical suspicion does not equate to criminal behavior, okay? And Texas arrest or search without evidence of a crime or probable cause contravenes Texas Code, Criminal Procedure Article 14.01 Section B, which requires that an offense be committed in an officer's presence or view to justify warrant this arrest. The officer, Chaz Roberts, who was the arresting officer at the time, did not have any probable cause or reasonable suspicion to even initiate the stop, and then once the stop was initiated, he didn't have any authority to continue with a search or arrest, especially not just based off mere traffic citation, like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute the traffic citation against me, and also the adjoining case that was with it. It was a possession of marijuana, which was dismissed, prior to even having these hearings. Okay, I'm going to continue on the failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment, through the normal judicial system, protects against due process, protects against arbitrary government actions, including unlawful and detention and seizure without legitimate legal basis, and Texas due process violations occur when the rights to fair and partial hearings are denied as well, and this is on the Texas Constitution Article 1 Section 19. Also the officer, as I mentioned, failed to sign affidavit of probable cause, which is required under Texas Code of Criminal Procedure Article 1505 subsection 2. Which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested on a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I receive of that, which is pretty much a blank report, and that it failed to have any attached affidavit the proper cause with it. Also, the prosecutor last hearing presented me with a discovery, which also failed to present any affidavit probable cause. Okay? Also, unlawful search and seizure falls on Texas Criminal Procedure Article 3823. The prosecutor alleged the odor of marijuana. The odor of marijuana law without physical evidence of proper cause of actual crime is insufficient to justify a vehicle search. Once again, was no testimony or affidavit. I am going to object to this. This is outside the scope of the hearing. Sustained. Let's stay within the scope of your motion. Well, this is all. This was all inside my motion as exhibits and as a brief. Allegations made by the state were not contained in the defendant's motion. Sustained. Let's move on, Mr. Bey. Okay, also the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of warrantless arrest and search, must be suppressed. Case dismissed under fruit of, poisonous tree doctrine, and that's Wong Sun versus United States of America Corporational Company, followed by citation of this doctrine.
For those who are unfamiliar with the case law of Wong Sun versus the United States of America Corporational Company, anno 1963, Justice Brennan wrote the majority opinion reversing the lower court and remanding for a new trial. The Supreme Court held that the police did not have probable cause to justify the arrests. With regard to Toy, the court should exclude all evidence found during the search, because they are the fruits of an unlawful search.
Fruit of the poisonous tree doctrine, a rule under which evidence that is the direct result of illegal conduct on the part of an official is inadmissible in a criminal trial against the victim of the conduct. If you have questions on any laws brought up in this episode of the new Hickey, please consult with a trained law professional. The channel owner never went to law school, has never taken the bar exam, and never sought to become a lawyer.
He also doesn't have a law license, so he is not practicing.
Mr. Bey, could you please spell out the law name for my court reporter, please? Yes, sir. It is W-O-N-G, first name, S-U-N, last name. Versus the United States of America Corporational Company. You can continue now. Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrest like probable cause. So for these reasons I request that the court grant this motion for reconsideration to the motion to dismiss for lack of a subject matter jurisdiction based on the due process violations, lack of proper cause, and other evidence that's lacking as well. Warrantless arrest like, as I mentioned in my motion, and also in my brief, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense, also evidence supporting the traffic stop and the alleged crime. They gave rise to these charges that I'm facing with the evasion of arrest, and charges of unlawful possession of a firearm, because for it to be an invasion of arrest, it has to be grounds for an arrest for me to invade. No evidence of this. So with the incompleteness of the discovery by the state, and failed documentation that the prosecutor failed to provide, with a record of events that would normally be captured in the police report, I am prejudiced from preparing the defense. And I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search, so I do compel that the full discovery, and I do request that this matter be dismissed, for the reasons stated before. Okay, your time is up, Mr. Bey. State. Quick question before you respond. Has Mr. Bey had access to discovery in this case? He was admonished for self-representation already. What we call pro se, but what he refers to as in propria persona sui juris. Can you provide some how long has he had access to discovery? Does he have access to everything in your file, please? Yes, Your Honor, that was actually the first point I was going to make in my response. Mr. Bey, Can you confirm the email address that you provided on the docket control order that was signed on July 23, 2024? It was. Could you please spell it? Bey@gmail.com. And Mr. Bey, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you a discovery which would include the PC affidavit that was cited by the arresting officer as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Who did you request it from?
The Rosenberg Police Department.
Okay. Please send me, I will do my best. But please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal, okay?
Okay, no problem.
Now, in response to some of these statements or allegations by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed, so we haven't been able to go through actual defense counsel for this judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th. Defense, was provided copies of all the media, Your Honor, so he does have access, at least from my understanding, to all the discovery. Now as to points made in his motion, first and foremost, Mr. Bey has not been charged by information with evading arrest. Mr. Bey has been charged with fleeing a police officer as well as unlawful carrying of a weapon. Now to his first point of hypothetical suspicion. I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion as seen in the PC affidavit as well as the offense report. The officer had on view offense for a traffic citation which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545,421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
Objection, Your Honor.
Give me your legal objection.
The prosecutor failed to, mention any case laws supporting his allegation with his brief, or anything.
The case law in support of that was in the response to your motion defense.
Yes, it was, Mr. Bey.
Case law makes it clear that the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer versus State, Roca versus State, Isaac versus State, and then he even cites additional case law, Camera versus State. So it's cited and there. Overruled. Continue. Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time the weapon was discovered within the vehicle as well as the contraband itself. I do not know. Again, going to one of the points defense made, I don't know what process rights are being violated here, which would warrant either suppression or dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. DC was found by the magistrate, so he's claiming he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out, so I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial, yet no witnesses have been presented for cross-examination, I will say, and obviously I will provide this to the defense electronically. After listening to Mr. Bey's testimony and hearing the state's testimony on the motion to reconsider for cases 24cc0104 and 24cc0109 is denied, these cases will go to trial. Stay away from Moorish science. It will ruin your life.
I need it quiet. Quiet, so that I can hear my ID.
You don't need to hear your ID.
I'm on the way to the fictitious and fraudulent mayor's office to command them to turn my electricity on at my sovereign domicile, located in Northwest Amexim. All rise and stand. Where, in the doohickey, is the fictitious manager? The what? The fictitious fraudulent manager? Of Strawmanville Electric Utility. I'm not sure. The fraudulent manager? The fraudulent manager does not have authority to operate on my land. I am from this land, and I do not have to follow orders from anybody. All I know is, I just left an affidavit upstairs to the acting county manager or city manager, whatever his fraudulent name is. He is not from the land. State your name and your nationality, for the people of the Moorish American National Republic Federal Government. My name is Jessica. And state your nationality. What, in the doohickey, is your nationality? I need to know if you are squatting on my land. What is your nationality? I'll be right back. All I know is, the utility services better be turned back on at my geographical location. All of you will be tamed by the military for police, for squatting on my land of Morocco, which is not the United States of America Corporational Company. And I will be sending the military back here, if all do not follow my commands. All are illegally squatting on my land. Do you see that? But the lights are back on. Like I said, I know who I am. I am Lord of this earth.
Lord, 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 I am Lord. Yeah, I am Lord.
And I am a Moor. And we are the title holders to this land. And that's why the electricity is back on at my geographical location, like I commanded.
Come on, Luna. Where's your super chat?
One more side, feel like that. One more side, chase the cat. Nobody talking me.
Amigos USA. Amigos USA. I'm in the library, where all the lies are buried. Amigos USA. Amigos USA. Showing the Moor in court, making a motion to reconsider going forward with a criminal trial, under Admiralty law, due to the gold fringes of the flag of the United States of America Corporational Company. Amigos USA. Amigos USA. Please buy one of my law classes. Only $125 per session. Whoa! Ha 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 ha. The last grape lollipop. Ha 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 ha. No way, butthead. Hey 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 hey. I always get the grape. It's not going to taste like grape when fighting over a grape lollipop. Title 18, 8 USC 1, 3, 2, 4.
This video will end with some tributes to Chille, DeleteLawz. Hope you will enjoy.
Hit the like button.
Hi, I'm at Maya Guerrero Restaurant, South Portland, Maine. I'd rather have a chile relleno than a Chille de Castro any day. Ha ha ha.
Hit the like button.
Here's Chille relleno de Castro. Hit the like button. Hit the like button.
Hit the like button.
Hi everyone, this is Buying Tall Girdle. I'll tell you what, this is like the best. Today's the 29th of September 2023. It's about 2:50 p.m. I want to let you know I love this Chille de Castro ad. So, I guess the question is, what headphones will go with these glasses? everybody wearing these glasses is also going to have a pair of headphones on them. I bet they have their own little trifolds they want to sell. Oh well. Greetings from Cologne, Germany.
Hit the like button. Hit the like button. Also, this is the perfect time to tell people about the Mullen Commission. Everyone should know about the Mullen Commission. The Mullen Commission is formerly known as the City of New York Commission to investigate allegations of police corruption and the anti-corruption procedures of the police department. Former Judge Milton Mullen was appointed in June 1992 by then New York City Mayor David N. Dinkins to investigate corruption in the New York City Police Department. Mullen's mandate was to examine and investigate the nature and extent of corruption in the department, evaluate the department's procedures for preventing and detecting that corruption, and recommend changes and improvements to those procedures. That's pretty much the Mullen Commission in a nutshell. Well, do you all now know about the Mullen Commission? Because of recent legal issues, I cannot sell my trifolds. Hopefully when court adjourns for the day, you can buy my trifolds. Later, Gator. Darn, there was no porno this time. I wanted to slap Omeo's USA with a $15,000 lien, payable only in dolarium,